express their feelings. That's very important. It's very important when you start your mediation, you turn to the claimant and the defendant, you said, listen, I know what's in my statement of claim, the claimant's issues, I know what's in the particulars, I know everything that's in there, but I want to hear from you, how did this happen? And engage them. Even setting up the mediation room is critical. My style, I tend to put the attorneys to the back and have the litigants to the front. That way I'm engaging them eye to eye, and of course they can turn to the attorneys if they do need to. Sometimes they don't feel they're allowed to speak or be heard. Let them be heard. Empower them. Let them know this is a situation that you expect them to have full participation. Do not insult them. Be very careful. You can't assume that the litigants know certain things. You've got to tell them everything. They've got to understand that you're not a judge. They've got to understand they're not in a court of law. Watch out for hidden emotions and hidden issues. Can't tell you how many times I've been to mediations and there's been hidden issues that have come out. The actual issue is not there on the paper, nowhere to be found, even in personal injury matters. Stall negotiations. Sometimes it may be necessary to adjourn. You've got to assess the mediation, adjourn. They may need to go away and get certain reports. The whole point is this: if you can settle it within the mediation, you will save yourselves time, energy, and money. So you've got to know when to adjourn at times and reconvene. Oh no. Okay. That basically is my presentation. I thank you all very much for listening to me. As I said, personal injury matters are peculiar matters, and I think that they are matters that can settle quite easily if you have the skill set, the mindset, the patience, and understanding. Thank you very much. Yeah, sure.
Thank you very much, John. It was very, very informative presentation. It was, what was particularly helpful, I found, was his identification of the requirement for stakeholders, some of the authority, exchange of documents, information, the importance of being prepared. I liked his use of the matchbox cars to allow his participants to talk about the accident. A reminder that listening and neutrality are essential tools for successful mediation, and that caucus in this particular instance is a particularly valuable tool. Thank you very much, John. We will field questions at the end of this session. Our next presenter is Jared Mendez. He's worked for most of his life in the general insurance industry, both in Trinidad and Tobago and in the Cayman Islands, where he was the president of that jurisdiction's insurance association. Managing claims and legal departments, managing operations, and functioning as the regional compliance officer for one of the region's largest general insurers. He has also managed the preparation and response to no less than 4 major storms in the region. Jared is currently the country head of the Insurance Company of the West Indies, which only recently began its operations here in Trinidad and Tobago, and which currently operates in 8 jurisdictions in the region, and he's also their VP, with responsibility for international business development. He's the holder of an MBA from UE. He's a trained paralegal, a certified motor adjuster, and a certified trainer. He's a certified mediator, and one of the few non-attorney mediators selected by the court to participate in its 2nd pilot project, held with a view to making mediation a formal part of the legal litigative process, and we heard about that this morning from Justice Devines. Jared is married to Linda, and they have 2 children, Ariella, who happens to be my daughter's best friend and who calls him Uncle Jerry, and Ariella is studying abroad, and Emilio, who is a student at Jared's alma mater, St. Mary's College. So I've known this gentleman for some time, and we've watched our daughters grow up together. So it is with great pleasure that I invite him now to share with you.
Thank you very much. Ladies and gentlemen, good afternoon. Please refrain from calling me Uncle Jerry. That's for only certain people. I must commend Mr. Bassi on his earlier presentation, because what it has done is eliminated for me certain fundamentals that he certainly covered in some detail. And it will allow me to speak perhaps to the experience I have had of being both an insurer as well as a mediator, and to talk a bit about bodily injury claims. I'll start by saying that insurers are perhaps their own worst enemies, in that we could do more for the world at large to understand what insurers really do. And we take your money and we give you a promise. And against the backdrop of that, there is a distinction I'd like to make. There are reputable insurers and there are not so reputable insurers. I have been blessed all my life to work for reputable insurers, but that hasn't prevented me from having had the experience of encountering disreputable insurers. And that brings me to the issue of claims. Bodily injury claims, by and large, and against the backdrop of claims in general, you should note, those of you who are not insurers, that the largest cause of general insurance company failure in the world has been the under-reserving of claims, bringing about the collapse of general insurers. And disreputable companies tend to under-reserve claims, and even reputable companies can sometimes not reserve adequately. One of the challenges that reputable insurance companies have is that they are, excuse me, they are targeted by so-called injured parties. There are parties with genuine injuries. There are parties with genuinely serious injuries. And then there are parties with what we would describe as fairly superficial injuries. But there are cabals out there in this market, as there are in other markets, of doctors, lawyers, ambulance chasers, who see claims against insurance companies as an opportunity to really print money. As our friend alluded to just now, the little bag, it's a much bigger bag in their eyesight. And against that backdrop, you have medical reports which, if you were to investigate, as some of the reputable insurance companies would do, the actual circumstances of the individual making the claim, you will see great discrepancies, inconsistencies between the medical reports submitted and the behavior of the party while under observation. And you would recognize that some of these claims are exaggerated. Against that backdrop of is the fact that there are attorneys who, notwithstanding the opportunities which may arise to settle matters, tend to drag them out, to take them through every single legal protocol and that's available in order to rack up costs. And what is becoming obvious in the industry is that the ratio of legal costs in relation to the settlement of claims is starting to spike. From a mediator's standpoint, I have had to engage in, I've sat in that position of neutrality for bodily injury claims, and I've come to the following conclusion. The Trinidad and Tobago market will be well served if mediation, as Justice Devines mentioned earlier today, if mediation is made a mandatory or a compulsory part of the legal system. But even before that, insurers would be well advised, and I hold no brief for any group of insurers or anyone. I'm speaking entirely from my own perspective. Insurers would be well advised to embrace the process of mediation, because of a lot of things will come out in mediation through the openness, the fact that the parties are present and given an opportunity to speak, and a lot of the artificiality, for want of a better word, that can be created through the legal system. And I don't want the attorneys to take offense, because we don't know that these things exist, the things that I've described. A lot of it will come out, and it will simplify the process of settlement. And from a mediator's standpoint, I have sat in the position of mediator for bodily injury claims, and I have seen people come to the table because they've been told to come, because they've been assigned to mediation by the court, but they have come very, very poorly prepared. In the issue of general insurance claims, there are two fundamentals. There's liability. Are you right or wrong? And as my friend mentioned, there can be degrees of contributory negligence which have to be ironed out, and that can be ironed out in discussion. And there is quantum. Having ironed that out, that issue of liability, you then get to the fundamental of how injured is this person, where are the supporting documents, what are the precedents on either side, the normal protocol, and you would understand this, I'm speaking very bluntly and very openly from my experience. The protocol is that the claimant's attorney will look at those precedents that are on the high side. The insurance company would look at those precedents for similar injuries that are on the low side, and they would normally arrive at a settlement somewhere in between. But when you get to a stage where you are mediating a matter, and people have barely looked at the issue of liability, and absolutely have not looked at the issue of quantum at all, you know that they didn't come prepared for the mediation, because the mediation is designed to bring the matter to a conclusion. Yes, parties do have to give. Sometimes a party with a very strong hand will consider yielding to some extent, because the long-term costs of having the matter go through all its various iterations makes a concession and a settlement today far more economical. And if you understand how insurance companies work, and they're very complex, there are things like reinsurance, they're regulated, etc., etc. There are reinsurance claims that have to be made. There are time limits within which those claims have to be made, because there's something called indexation. I'm becoming a little too technical, but what that means is if the claim takes too long to settle, notwithstanding what your fixed retention is, that fixed retention goes up the longer the claim takes beyond a certain given point in time. So with all of those risks inherent in the current scenario, mediation with trained mediators and with the insurance industry training people in negotiation and mediation and embracing the process of mediation even before it becomes part of the law, and certainly preparing themselves for when it does become part of the law, would be something I would advocate in the strongest possible voice. I don't want to go on and on. I've put basically my points on the table as quickly and as briefly as I can, and I'll be open to questions when our chair opens the floor to questions. So I thank you very much.
Thank you very much, Uncle Jerry. That was a very frank assessment of our insurance climate in this country, and it was very valuable because Jared brought to bear his skill set as an insurer and used that to assess the climate of mediation with respect to this particular topic, and emphasized to us the importance of mandatory mediation for personal injury claims. So thank you very much, Jerry, for bringing that gift to the table. Our next speaker I met when we started, or I started, a contentious matter against him. He's the attorney on the other side. And we